Hello, good evening, everyone. Today is day 7 of our daily drill for breaking prelims UPSC target 2026, right? And we have been doing this since last Monday, and this is our 7th day. And right now, polity has been going. One day was dedicated to current affairs, and we are helping you to revise basic facts and articles and anything on details about the topic, about the core topic. Along with that, people who have read basic subject ones, we are telling how to use common sense confidently also, right? So people, there are a lot of students who have studied things several number of times, yet they fail in the, guessing the question and guessing the answers, or they lack confidence, ki shall we dare so much to think like that. So we'll teach, so we here are trying to teach you that aptitude also, along with revising basic information and details of that particular subject. Just keep in mind one thing, that without reading and piecing not be upright. So I'm talking to people when I'm writing it. So hello, good evening, Bhagri, good evening, Amu, good evening. Let's start our today's session. So without reading, no use of common sense. I'm trying to say, I hope you have read the subject, and then how to not make mistakes, how to avoid silly mistakes, that we will do. Today's topics were Judiciary, Supreme Court, High Court, subordinate courts, and there are tribunals as well, right? So we'll discuss. There was a test in the morning from 9:30 a.m. to 10 a.m. every day from Monday to Friday, which a lot of students have given, and there they download the question, give the test, 25 question test in 30 minutes, and in evening we are discussing and also sharing the solution. So let's start with today's discussion of this. Description was for those people who are new to our, one second, who are new to our videos, right? People who have been seeing us already know about it, right? So let's start with today's first question. Question number 1. Okay, so I hope you can see the question very clearly, right? It is day 7 for polity. I hope you have read, basic articles. I keep telling you to refer to PM Bakshi, which is the most important book, sometimes even more important than Lakshmi Kant. Question number 1. A writ of prohibition is an order issued by the Supreme Court or High Courts. So they're talking about writs. And there's several kind of writs. What are the several kind of writs? Habeas corpus, mandamus, prohibition, certiorari, right? So prohibition is one of the types of writs which both Supreme Court and High Court can issue. So what does writ of prohibition mean amongst all this option? A government officer prohibiting him from taking a particular action. Option B, Parliament Legislative Assembly to pass a law on prohibition. Option C, the lower court prohibiting continuation of proceedings in a case. Option D, the government prohibiting it from following an unconstitutional policy. So the first option A, a government officer prohibiting him, the order issued by Supreme Court or High Court to a government officer prohibiting him from taking a particular action. So this order to executive happens in mandamus, not in prohibition, right? The Parliament Legislative Assembly to pass a law on prohibition, that is not a writ. That is not how writ works, that Supreme Court can pass a writ or order, issue an order to Legislative Assembly to pass a law. That is not how writ works. Option C, the lower court prohibiting continuations of proceedings in a case. Yes, that is the right option. The Supreme Court and the Supreme Court and High Court are prohibiting lower courts to not go further in this case. That is what is option C. Let's move to the next option. Next question. Question number 2, statement 1. The Supreme Court of India has held in some judgments that the reservation policies made under Article 16, Clause 4 of the Constitution of India would be limited by Article 335 for maintenance of efficiency of administration, right? So this was which case? Indira Sahani case, right? Very important case related to reservation for backward classes. Statement 2, Article 335 of the Constitution of India defines the term efficiency of administration. Firstly, there are very few things that Constitution define. Like yesterday also we were reading Office of Profit. One of the statement was this only, that Constitution defines Office of Profit. So similarly in this Article 335, they mention the term efficiency of administration, but they do not define the term. So statement 2 is wrong. It's incorrect. So if statement 2 is incorrect, we have the option C, right? And yes, Supreme Court of India says that reservation policies under Article 16, Clause 4 should take care of efficiency of administration mentioned under Article 335. So the option will be here C. Let's move to the question number 3. And if you want to see the solution after this discussion, at the end of the discussion, the solution will be uploaded in the comments as well as description. So let me just go fast forward with you and let me finish this discussion as soon as possible. And trust me, all of those who think that right now prelims preparing for prelims is not important, let us prepare for mains. Trust me, if you'll do this with me for all the subjects, you will know so many facts that it will help you not just in prelims but also in mains. In fact, knowing articles is more important for mains answers than prelims. In prelims, hardly 1 or 2 questions will come asking specifically about articles. But in GS paper 2, a lot of questions you will write mentioning a lot of articles. So remembering articles is very important, right? So question number 3, with reference to Indian judiciary, consider the following statements. Any retired judge of the Supreme Court of India can be called back to sit and act as Supreme Court judge by the Chief Justice of India with prior permission of the President of India. Yes, for that, President's consent is required. Second statement, a High Court in India has the power to review its own judgment as the Supreme Court does. Here, I think both the statements are right. A retired judge of Supreme Court, when there is lack of judges, when there is vacancy, when more cases are to be handled, then a retired judge can be asked to again sit and discuss on and sit on few cases, right? So here both options are, both statements are correct, and the answer will be C. Which are the articles? Do remember the articles. So Article 128. So articles for Supreme Court ranges from Article 1 for Supreme Court is from 124 to 147. Please remember. So when we are talking about Supreme Court, right? So Supreme Court's article ranges from 124 to 147. It starts from 124. Always remember that last article is 147. A very important article is 142, on which several times mains questions has been asked, right? So remember, Article 128 allows CJI to request retired SC judges to act to sit with President's consent. High courts have inherent power of review similar to Supreme Court under Article 137. Please try and remember these articles. Okay. Let's move to the next question. With question number 4, with reference to Constitution of India, prohibition or limitation of provision contained in ordinary law cannot act as prohibition or limitation on the constitutional power under Article 142. What is this article on 142? This article gives Supreme Court, power to do complete justice. That is what is the main line of that. 142, enforcement of decrees and orders of Supreme Court and orders as to discovery. So this could mean which one of the following. So if you know what is Article 142, this question is sorted. Right? This has been in news several times. The decisions taken by Election Commission of India while discharging its duties cannot be challenged in any court of law. This is not right. It can be, but not for Article 142. The Supreme Court of India is not constrained in the exercise of its powers by laws made by the Parliament. This is the right answer. Supreme Court, while taking any decision under any case to do complete justice, will not be bounded by Parliament laws. They will freely act and they will freely work for the justice of society. Justice of society. That's why Article 142. Please try and remember. In the event of grave financial crisis in the country, the President of India can declare financial emergency without the council. This is wrong. This doesn't happen, and this doesn't happen only. So, President of India cannot declare financial emergency just like that. State legislature cannot make laws on certain matters without the concurrence of union legislature. This has nothing to do with Article 142. So the option is B. Question number 5. Consider the following statement regarding impeachment of judges. Very important. Impeachment of judges can be asked in prelims and has been asked in mains also. Right? The motion to impeach a judge cannot be rejected by the Speaker of the Lok Sabha as per the Judges Inquiry Act 1968. Now, this is wrong. If you read the impeachment procedure, firstly, there is a like 50 members of Rajya Sabha and 100 members of Lok Sabha have to, give their approval to first initiate this. Then Speaker can either reject or accept it. The Speaker has power. So option 1 is wrong here, right? So firstly, a removal motion is, given. So this part that it cannot be rejected by the Speaker is wrong statement. The Constitution defines what constitutes incapacity and proved misbehavior of Supreme Court. So again, I am saying Constitution does not define much. It only mentions. Okay, so it mentions incapacity and proved misbehavior. These are two reasons for which Supreme Court judges can be, can be impeached or removed by Parliament. So this again is the wrong statement. The details of the impeachment process are given in the Judges Inquiry Act 1968. That is right. For voting on impeachment motion, it requires support of majority of total membership and 2/3 of members present and voting. Yes, special majority is required for such an important thing. It cannot be done casually. So the correct statements are 3 and 4. So option will be C. You can read the solution. Question number 6. Which of the following is the custodian of the Constitution of India? Now this question was asked in 2015. 2015 prelims question. Right? So a lot of people were confused whether it is President of India, whether it's Supreme Court of India, but it is actually Supreme Court of India because it has the power of having judicial review over over all the parts of the Constitution. So Supreme Court is the custodian and the final interpreter and guardian of the Constitution. Next question, question number 7. Which of the following are included in the original jurisdiction of the Supreme Court? Now you should know, if you open the chapter of Supreme Court in Lakshmikant, there are few kinds of jurisdiction. One is original, then there is advisory, then there is appellate, then there is writ jurisdiction. So you should know all these types of jurisdiction. Okay, the first type is original. Okay, the Supreme Courts. So whenever we were talking about federalism, okay, when we talked about federalism, so we always said one of the most important features of federalism, one of the most important, criteria for a country to be federal is independent judiciary. So for that is the main work of Supreme Court, one of the main works, okay, original jurisdiction. So if something happens between center and state, state and state, so one unbiased authority which will give the right, right conclusion or right final, whatever it will be the solution. So that is what is the original jurisdiction. So between center and one or more states, between the center and any state, and between 2 or more states. Okay, so a dispute between the government of India and one or more states, that's right. A dispute regarding election to either house of the parliament, that doesn't come in original jurisdiction. Original jurisdiction only have 3 things: center and one or more states, that is given in the option statement 1. Right, between center and any state. So center and state on one side and one or more other states on the other side, and between 2 or more states. Okay, so this is the only option. Union territory is considered to be part of center. So it is not considered separate for Article 131. So original jurisdiction is mentioned under Article 131. Remember all this, okay? So the answer will be, I think, only option 1. Yeah, okay, there was a dispute between 2 or more states. So this is also right. So right answer will be 1 and 4, option C. Article 131A, Article 131 clause B. What are the provisions to safeguard the autonomy of the Supreme Court of India? How to make sure that they are independent? So while appointing the Supreme Court judges, the President of India has to consult the Chief Justice of India. This is what is collegium system, right? This is the way appointment of judges is happening in our country. The Supreme Court judges can be removed by the Chief Justice of India only. So this doesn't happen. Supreme Court of Justice can only be removed by impeachment procedure done by the Parliament. The salaries of the judges are charged on the Consolidated Fund of India, to which the legislature does not have to vote. All appointments of officers and staffs of the Supreme Court of India are made by government only after consulting. So this is also not right, right? So first is right and fourth is right. It is charged on the Consolidated Fund of India, right? So legislature will have to pass that. Once the act, parliament by law will decide what will be their salary and everything. But every year, when the budget will be passing, they'll not vote upon it. Okay, they'll not. That is fixed. Okay, that cannot be changed, especially after the judges has been given that position. It can't be changed after that. So the answer will be 1 and 3. Option A. Right? Yes. Article 124, Clause 2 talks about presidential consultation with CJI, which is collegium system. And Article 125 talks about judicial salaries. The power to increase the number of judges in the Supreme Court of India is vested in. Who can increase the number of judges? So for that cannot be one person. That cannot be one person. That cannot be government. If it will be government, it will keep doing anything. It will increase the number, hire its own people, right? That is not Parliament. Parliament has that power, okay, to increase the number of judges. What is the current number of judges? What is the current number of judges in Supreme Court? Yes, Bhageshri? Amu, anybody answer? What is the current number of judges in Supreme Court of India? So in 2019, with this Judges Act, the number was increased to 33 and plus one CJI. So total 33 SC judges plus one, say total 34 judges are there. Okay, that is done by Parliament only. Okay, it has been done through several years. Law Commission is just a recommendatory body. The power of the Supreme Court of India to decide, that's a question that has been repeated. Supreme Court of India to decide disputes between center and the state falls in the original jurisdiction, Article 131. Okay. You can remember. How will you remember this article, Article 131? That it is original jurisdiction about center and states. Center and a state on one side, other states on one side, and 2 or more states, right? So here you can see. So if you consider 3 as center and 1 as states, so either center is this or alone, right? Or either it can be between, center and other states. So 1 and 1 are states and they're on the either side of the center, right? So this is the dispute that the Supreme Court will be deciding upon. Let's move to the next article. Next question. Question number 11. The judges of the High Court of the states in India are appointed by the governor of the state. Judges of the High Court of the states in India are appointed by the governor of the state, just as the judges of the Supreme Court are appointed by the president. The Constitution provides for consultation with Chief Justice of India and the governor of the concerned state in the appointment of High Court judges. So one very important thing that you should know, like Supreme Court judges are hired by president, similarly High Court judges are also hired by president. Though their removal and other things will depend on the state and governor, but appointment is done by president. So they are not appointed by the governor, and this statement 1 becomes wrong. As soon as statement 1 is incorrect, the option is D. And both statements are not incorrect in these kind of options. So second statement is right. The Constitution provides for consultation with Chief Justice of India and the governor for the appointment of High Court judges. Next question with reference to writ jurisdiction of high courts in India. Consider the following statements. High Court can issue writ jurisdiction habeas corpus, mandamus, prohibition, certiorari, and quo warranto only for the enforcement of fundamental rights. So this is also not right. High courts has wider writ jurisdiction than Supreme Court, right? And they have High Court has power of writ jurisdiction under Article 226. It is wider than what Supreme Court gets under Article 32, right? So this is a wrong statement. The next statement, statement is the territorial jurisdiction of a High Court for issuing writs extend beyond the territorial limits of the state. The territorial jurisdiction of High Court for issuing writs extend beyond the territorial limits of the state. So this happens only when the person or the authority comes under the jurisdiction of High Court. When certain person or the authority comes under the jurisdiction of High Court, only then this happens. Okay, so this is a possible statement. This is the right statement. So jurisdiction of High Court can extend beyond that state if the person or the authority over which High Court is deciding is in other states or is beyond the territorial jurisdiction of that state. Okay, so per statement, so it will be option B, right? So High Court can issue writs beyond state boundaries if person authority is within jurisdiction. The High Courts in India, question number 13. High Courts in India have administrative control over district and session courts. We have read the first paragraph of Supreme Court or Judiciary. If you read, they'll say India has integrated hierarchical judiciary system where Supreme Court is on top, High Court is below it, and then the district court and other session courts, right? So High Court sits above district court and session court. This is written in the first paragraph of Supreme Court. Please, right? So please read. So all subordinate courts, including tribunals and special courts, no. Some tribunals are not under the High Courts. They're, they're special in their arena of in their jurisdiction, and it is not coming directly under the High Courts. Only civil courts, but not criminal courts. Wrong. Both civil courts and criminal courts can come under High Court. Courts established by state government, but not those established by central. There's nothing like that. There's nothing like that. So the answer is district and session courts within their territorial jurisdiction. So High Court of Delhi will have jurisdiction over district and session courts of Delhi. Okay, let's move to the. And there's article also, Article 235 gives High Court administrative control over district courts and subordinate courts. Let's move to the next question, question number 14. No criminal proceeding shall be instituted against a High Court judge in any court during his term of office. Yes, I mean, for such high, level people of high designation, criminal proceedings are not allowed during their term, especially governor, president, High Court. So this is true. The power to transfer High Court judge from one High Court to another is vested in the president after consultation with the Chief Justice of India. This also seems to be true. We have just discussed. So both statements are right, both 1 and 2. To read the article, Article 218 and Article 222, right? Do read this Article 222. मतलब कोई भी स्टेट, उसको भी स्टेट समझो, कोई इसको भी स्टेट समझो, कोई भी स्टेट में जाने के लिए अगर हाई कोर्ट के जज का ट्रांसफर करना है तो प्रेसिडेंट को चीफ जस्टिस ऑफ इंडिया के साथ कंसल्टेशन करना है. ठीक है, ये याद रखिएगा. आर्टिकल 218, हाई कोर्ट जज के अगेंस्ट क्रिमिनल प्रोसीडिंग्स नहीं हो सकती. इतने सीनियर डेजिग्नेशन के अगर अगेंस्ट क्रिमिनल प्रोसीडिंग होगी तो बहुत सारे इंपॉर्टेंट वर्क हॉल्ट पर आ जाएंगे, राइट? In India, legal service authorities provide free legal services to which legal service authority, right? So there is NALSA, National Legal Service Authorities. There are for states also, right? Provide free legal services to which of the following type of citizens? Person with an annual income of less than 1 lakh rupees. Now this is true. Transgender with an annual income of less than 2 lakh. So you will know it is true or not only if you have read it, right? So I have read it. So that's on that basis I'm saying yes, person who has an annual income less than 1 lakh can get free legal service from National Legal Service Authority and others. Transgender with annual income of less than 2 lakh. Okay. Members of OBC with annual income of less than 3 lakh, no. If transgender is given 2 lakh, why will OBC will be given 3 lakh? They will be considered almost on equal lines, right? So that is also 2 lakh only. Okay. So this is the wrong statement. All senior citizens know based on the money, based on their monetary status. If they have a lot of money, senior citizens are very rich, they'll not get free legal services, right? So the answer is 1 and 2, and option is A. Okay, so general income limit is 1 lakh, for transgender is 2 lakh, OBC is also 2 lakh. If you don't know, you can read it now. District judges in India are appointed by the governor of state in consultation with the High Court, the High Court of the state in consultation with the governor. No, the Chief Justice of the High Court independently, one person cannot decide all this. The State Public Service Commission may take exam, but it is not an appointing authority. But not appointing authority. Please remember. Okay? So this is also wrong. So remember this thing. Like High Court judge, how they are appointed? President, उनसे ऊपर कौन आता है? President in consultation with Chief Justice of India. Similarly, district judge कैसे होगा? गवर्नर जो उनसे ऊपर है, गवर्नर इन कंसल्टेशन विद हाई कोर्ट जज. एक एक लेवल ऊपर चले जाओ. ठीक है. और मेन प्रेसिडेंट गवर्नर अपॉइंटिंग अथॉरिटी है इसमें. सीजीआई एंड हाई कोर्ट आर कंसल्टिंग पीपल, राइट? सो डू नॉट कंफ्यूज. ठीक है. हाई कोर्ट से बस कंसल्ट करेंगे, अपॉइंटिंग अथॉरिटी ये है. ठीक है. सो द आंसर विल बी ऑप्शन ए. गवर्नर डिस्ट्रिक्ट जजेस को अपॉइंट करता है in consultation with the High Court. With reference to Lok Adalats, consider the following statement. Lok Adalats have jurisdiction to settle matters at pre-litigation stage and pending cases in courts. Yes, this is true. Clear. Lok Adalat सब कुछ settle कर सकता है. जो अभी तक कोर्ट में गए हैं वो केसेस भी, जो नहीं गए हैं वो केसेस भी. The decision of Lok Adalats are binding on the parties and have the same status as the decree of civil court. This is also true. Right? So both the 1 and 2 statements are right. Option will be C, both 1 and 2. Question number 18, with reference to scheduled areas in India, consider the following statement. Within a state, the notification of area of a scheduled area takes place through the order of the president. Yes, president gives that order. The largest administrative unit forming the scheduled area is the district, and the lowest is the cluster villages of the block. This also seems to be right. If district से ऊपर नहीं होगा. Chief Minister of the concerned states are required to submit annual reports to the Union Home Ministry on the administration of scheduled areas. अगर आप 5th schedule और 6th schedule पढ़ोगे, वहाँ Chief Minister कहीं लिखा ही नहीं है. It's not mentioned. जहाँ scheduled tribes और scheduled area discuss हैं, वहाँ Chief Minister mentioned ही नहीं है. तो Chief Minister की जगह कौन रिपोर्ट सबमिट करता है? गवर्नर सबमिट करता है. ठीक है. तो ये स्टेटमेंट गलत है और आंसर है 1 and 2. प्रेसिडेंट डिक्लेयर करता है थ्रू कॉन्स्टिट्यूशनल ऑर्डर्स अंडर 5th शेड्यूल और एडमिनिस्ट्रेटिव हायरार्की डिस्ट्रिक्ट टू विलेज क्लस्टर्स. Consider the following statement. It is the governor of the state who recognizes and declares any community of that state as a scheduled tribe. हम अभी पढ़े, प्रेसिडेंट करता है. ठीक है. तो गवर्नर नहीं करता है. ठीक है. अभी पढ़ा हमने जस्ट ऊपर 5th शेड्यूल के अंदर प्रेसिडेंट करता है. A community declared as a scheduled tribe in a state need not be so in other state. That is also true. हो सकता है कोई community एक state में scheduled tribe है और दूसरे में शायद OBC है, वो भी नहीं है. That is a possibility, right? So statement 1 is wrong. Statement 2 is right. So the answer will be B, option B. ठीक है. Let's move to question number 20. The provisions in 5th schedule and 6th schedule in the Constitution of India are made in order to 5th and 6th schedule क्या? Schedules याद रहने चाहिए 12 के 12. Please remember, you should remember all the 12 schedules. 5th and 6th schedules are tribal areas. 6th schedule के states आप लोगों को पता होने चाहिए. ATM square, अरुणाचल प्रदेश, त्रिपुरा, मिजोरम and मणिपुर, right? मिजोरम and मणिपुर है ना, कि मेघालय and मिजोरम. Which are the states in ATM square? बताइए मुझे जल्दी, है ना. तो 5th and 5th schedule के भी states को देखो कौन से हैं और 6th schedule के भी states को देखो कौन से हैं. ठीक है, तो किस बारे में है? शेड्यूल्ड ट्राइब्स को कैसे सेल्फ गवर्नेंस का पावर दिया जाए। ठीक है, तो सो इट इज अबाउट प्रोटेक्टिंग द इंटरेस्ट ऑफ शेड्यूल्ड ट्राइब्स। वेरी इजी क्वेश्चन। ऐसा क्वेश्चन गलती मतलब जो अगर यूपीएससी में आया तो काफी इजी क्वेश्चंस में होता है। ठीक है, बाउंड्रीज ऑफ स्टेट से इसका कोई लेना देना नहीं है, पंचायत की अथॉरिटी से भी नहीं है, ऑल द बॉर्डर स्टेट से भी नहीं। 20 का ऑप्शन ए है। 21st का लेट्स सी 21st क्वेश्चन। द गवर्नमेंट एनैक्टेड पैसा एक्ट। पैसा क्या है? पंचायत एक्सटेंशन टू शेड्यूल्ड एरियाज। विच वन ऑफ द फॉलोइंग इज नॉट आइडेंटिफाइड एज इट्स ऑब्जेक्टिव? अगर आप अभी लोकल सेल्फ गवर्नमेंट का चैप्टर पढ़ोगे इन लक्ष्मीकांत, तो पैसा एक्ट अलग से लिखा है, उसके 10-12 पॉइंट्स अच्छे से लिखे हैं। उनका पर्पस क्या है? उनका पर्पस है सेल्फ गवर्नेंस देना। ऑफ कोर्स वो चाहेंगे यार सेल्फ, ये पंचायत का काम ही है ये सेल्फ गवर्नेंस का पावर देना, तो ये सही है। तो क्वेश्चन क्या पूछ रहा है? विच ऑफ देम इज नॉट आइडेंटिफाइड एज ऑब्जेक्टिव? तो जो ऑब्जेक्टिव नहीं है, कौन सा ऑप्शन गलत है? ट्रेडिशनल राइट्स रिकॉग्नाइज करना, ऑफ कोर्स करना है। टू क्रिएट ऑटोनॉमस रीजन। अब ऑटोनॉमस रीजन ये पैसा नहीं दे रहा, ऑटोनॉमस रीजन 6th शेड्यूल देता है पर पैसा नहीं देता है। ठीक है, तो ये गलत है, इसलिए ये आंसर है। और फ्री ट्राइबल पीपल फ्रॉम एक्सप्लॉयटेशन, ऑफ कोर्स ये भी एक एम है, ये भी एक ऑब्जेक्टिव है पैसा एक्ट। ठीक है, ये तो बहुत आसान क्वेश्चन है, ये तो पता होना चाहिए। विच ऑफ द फॉलोइंग ऑर्गेनाइजेशंस बॉडी कंसिडर द फॉलोइंग ऑर्गेनाइजेशन? नेशनल कमीशन फॉर बैकवर्ड क्लासेस, ह्यूमन राइट्स कमीशन, लॉ कमीशन, कंज्यूमर डिस्प्यूट रिड्रेसल कमीशन। विच ऑफ द अबव आर कॉन्स्टिट्यूशनल बॉडीज? तो जब मैंने पढ़ाई शुरू की थी उस हिसाब से बताऊं तो कोई भी नहीं थी कॉन्स्टिट्यूशनल बॉडी, बट 2019 के आसपास 102nd अमेंडमेंट एक्ट से बैकवर्ड क्लासेस वाली बॉडी को कॉन्स्टिट्यूशनल बॉडी बना दिया गया। ठीक है, जो बैकवर्ड एनसीबीसी को बना दिया गया, तो इसलिए इनमें से, और एनएचआरसी इज अ स्टैट्यूटरी बॉडी। ठीक है, ये तो नेशनल लॉ कमीशन स्टैट्यूटरी भी नहीं है, इसको आप रिकमेंडेटरी बॉडी, एडवाइजरी बॉडी या एग्जीक्यूटिव बॉडी समझ लो। ये एक स्टैट्यूटरी बॉडी है कंज्यूमर डिस्प्यूट वाला। ठीक है, तो इसका आंसर है ओनली 122 का। ठीक है, एनसीबीसी का आर्टिकल क्या? आर्टिकल 338 102nd अमेंडमेंट एक्ट से इंट्रोड्यूस किया गया है। एनएचआरसी का एक्ट क्या है? प्रोटेक्शन ऑफ ह्यूमन राइट्स एक्ट 1993। ठीक है, और कंज्यूमर प्रोटेक्शन एक्ट 1986 से ये बना है। Let's come to question number 23. With reference to National Human Rights Commission, consider the following. NHRC can investigate violation of human rights by private parties and non-state actors. Private parties और non-state actors का पावर अभी नहीं है। सिविल सर्वेंट्स क्या कर रहे हैं, गवर्नमेंट क्या कर रही है, पहले ये देखना है एनएचआरसी को। उनके तरफ से कुछ एक्शन हो रहा है जो ह्यूमन राइट्स के अगेंस्ट है, तो वो तो इसलिए ये फर्स्ट स्टेटमेंट गलत हो जाता है। द चेयरपर्सन ऑफ एनएचआरसी मस्ट बी अ फॉर्मर चीफ जस्टिस ऑफ इंडिया, ये तो सही है, और अ सिटिंग जज, ये गलत है। तो ओवरऑल ये स्टेटमेंट गलत हो जाता है। तो आंसर which of them above are correct? None are correct, both, neither one nor two. तो फॉर्मर चीफ जस्टिस ऑफ इंडिया ही बस चेयरमैन बन सकता है एनएचआरसी का, सिटिंग जज नहीं बन सकता है। ठीक है, लेट्स मूव टू द नेक्स्ट क्वेश्चन। Administrative tribunals established under Administrative Tribunals Act 1985 have jurisdiction over all disputes involving government employees and defense personnel. Defense personnel का अलग ट्रिब्यूनल होता है। ठीक है, service matters of civil servants excluding those covered by other specialized tribunals, only disciplinary proceeding against government employees, appeals from decision of central and state government. तो इसमें सबसे सही ऑप्शन बी लग रहा है। एडमिनिस्ट्रेटिव कैट जो बना था वो सिविल सर्वेंट्स के लिए ही बना था। ठीक है, उनके ये सारे मैटर्स, सर्विस मैटर्स को के ऊपर डिसीजन लेने के लिए, और उसको छोड़ के कोई और ट्रिब्यूनल अगर स्पेशली बनी है तो उस पर इंटरफेयर नहीं करेगा। ठीक है, लास्ट क्वेश्चन ऑफ द डे। Tribunals in India are alternative institutions to courts for educating specific categories or disputes with specialized expertise. ये पॉइंट बिल्कुल सही लग रहा है, ट्रिब्यूनल्स को बनाया इसलिए गया है क्योंकि कोर्ट्स के पास बहुत केसेस हैं, वो नहीं डील कर पा रहे हैं इतने सारे बर्डन से। तो ऑल्टरनेटिव इंस्टीट्यूशन है, स्पेसिफिक कैटेगरी और उस एरिया में इनकी एक्सपर्टीज होगी। ठीक है, द एस्टैब्लिशमेंट ऑफ ट्रिब्यूनल इज मैंडेटेड बाय कॉन्स्टिट्यूशन टू रिड्यूस द बर्डन ऑन, मैंडेटेड बाय कॉन्स्टिट्यूशन, मैंडेट नहीं करता कॉन्स्टिट्यूशन, इसने भले लिखा है, ठीक है, भले मेंशन्ड है, कि आप कर सकते हो, बना सकते हो, पर मैंडेट नहीं करता कॉन्स्टिट्यूशन की बनाना जरूरी ही है। ठीक है, ये कौन से पार्ट में है ट्रिब्यूनल्स? पार्ट 14, पार्ट 14A, वेट, पार्ट 14A में है। ठीक है, ये बाद में ऐड हुआ है, कौन से अमेंडमेंट एक्ट से हुआ है ये भी पता होना चाहिए। ठीक है, ट्रिब्यूनल तो मैंडेटेड नहीं है, बनाया जा सकता है, बस इतना है। ठीक है, तो ये अगेन गलत हो जाता है, और स्टेटमेंट 2 अगर इनकरेक्ट है तो ऑप्शन विल बी सी is the last question of the day. Tribunals provide specialized adjudication for specific disputes. ठीक है, कॉन्स्टिट्यूशन परमिट करता है पर मैंडेट नहीं करता। शब्दों पे ध्यान दीजिए, डिफाइन, मेंशन, मैंडेट, परमिट्स, ये क्या क्या बोल रहा है, इन सारी बातों पर थोड़ा सा ध्यान दीजिए, तो आप ऑटोमेटिकली कुछ क्वेश्चन सही कर लोगे। आप समझ जाओगे कि हाँ कॉन्स्टिट्यूशन ऐसी बातें तो नहीं करता, अगर आपने और एटलीस्ट कुछ नहीं है तो ऐसे अंदाज आए जाते हैं। ठीक है, तो आज के लिए इतना काफी है। कल के टॉपिक्स में आप लोगों को बता देती हूँ, आप लोग शेड्यूल डाउनलोड कर सकते हैं, क्वेश्चन पेपर डाउनलोड कर सकते हैं, सुबह शेड्यूल डाउनलोड कर सकते हैं जो हमारा अभी से 100 दिन तक चलेगा। पॉलिटी बस पिछले हफ्ते शुरू हुई है, अभी सारे टॉपिक्स के इंपॉर्टेंट क्वेश्चन एवरीडे डिस्कस होंगे। इस आधे घंटे में आप अपना टॉपिक्स रिवाइज कर सकते हैं। ठीक है, तो मैं आपको बता देती हूँ कल किस टॉपिक्स पे हम डिस्कस करेंगे। लोकल सेल्फ गवर्नमेंट जो थोड़े बहुत थे यार, सिस्टम ऑफ पंचायत, म्यूनिसिपैलिटी, यूनियन टेरिटरी, शेड्यूल एंड ट्राइबल एरिया, शेड्यूल कास्ट, स्पेशल प्रोविजन फॉर सर्टेन क्लासेस, ये सारे टॉपिक्स पे कल डिस्कशन होगा। बहुत बड़े चैप्टर्स नहीं है, चाहो तो आप रिवाइज करके आ सकते हो, एंड विल डिस्कस ऑन दिस टुमारो। एंड ये वीक में और अगले वीक के मंडे तक ही पॉलिटी डिस्कस होगा, उसके बाद ज्योग्राफी स्टार्ट होगा। प्लीज लुक एट द शेड्यूल, अटेम्प्ट द क्वेश्चन, लर्न, धीरे धीरे आधे घंटे में भी आपका काफी रिविजन हो जाएगा।